The New York State Court of Claims is often a below-the-radar court in the state court system. It rarely makes news. Its jurisdiction is limited to civil cases against the state and some of its entities. There are no jurors, so each case is decided by a judge. And since the judges are all appointed by the governor, they never interact with the public in the way that judges campaigning for public office do. Welcome to Amici, news and insight from the New York courts. I'm John Carr. Today we're going to demystify the Court of Claims with three guests uniquely qualified to do so. The Honorable Richard E. Sise, the acting presiding judge of the Court of Claims, and Court of Claims judges Catherine Leahy-Scott and Ramón Rivera. Your Honors, thank you for joining the program. Judge Sise, why don't we start off with you? What is the Court of Claims and how did it come to be?
Let's go back to 1620. When that Mayflower left England with the 102 pilgrims aboard, heading for the New World, if you will, some religious freedom, and struck a rock, stopped right over there in Plymouth, Massachusetts. And the colony was begun. But the most important thing about that voyage, those pilgrims brought with them the beginning of, if you will, the justice system, town justices eventually, but that sovereign immunity that was enjoyed by the King of England came over with those pilgrims. So this state of New York and all states initially had sovereign immunity. You could not sue the state, could not sue the state of New York without having special permission from the legislature. They would pass certain appropriation bills that allowed a citizen to sue. So sovereign immunity, you can't sue the state of New York. Court of Claims is the court in which you sue the state of New York. How did we get there? There are certain things that happen in the history of our state that are important to know, certain things that governors have done over the years that have really had great impact on the court itself. From the beginning of the New York State colony to becoming a state in 1788, sovereign immunity was in place. In 1817, the Erie Canal Act was passed. Governor D. Wood Clinton was the man who pushed that. So there was a way to get the ships from the Atlantic Ocean up the Hudson, cross the canals to the Great Lakes. And, you know, that's another whole podcast, but it changed the world. They built the canal. And when they built the canal, they had to take the land across the state of New York. And indeed, they decided within that Canal Act of 1817 to allow the homeowners to bring a direct action against the state of New York to be compensated for the taking of their land. So that was the first, if you will, statutory provision and the constitutional provision that allowed a citizen to sue the state of New York. And over the years, that immunity has dissolved. So during the construction of the canal, there was some damage to the contiguous property, so they could bring claims for the damage to the property. And then people might have been injured by the state employees constructing, as it were, or traveling upon the Erie Canal, so they could sue the state directly for those torts. It wasn't until, and again, there was many different, if you will, bodies. At one point, it was called the Board of Canal Appraisers. Another time, the Canal Commissioners, Board of Audit, Board of Claims, Court of Claims, back to the Board of Audit. These are the different names of the entities that actually heard these claims. And it wasn't until, let's see, I think it was 1949 that the Court of Claims achieved constitutional status and a permanent status, because these other entities were comprised. They would serve for a while, the legislation would change it up and so forth, and people came and went. But they needed to have some permanency, and the people of the state of New York in 1949 voted in that constitution to create a constitutional court. And as I said, over years, the immunity has just been waived. There's very little that you can't sue the state of New York for, like any other corporation. And currently, it's a statewide court. You know, over time, additional matters occurred during history. In 1971, that horrific uprising at Attica. Prior to that uprising, citizens of the state of New York who were indeed imprisoned could not bring a claim directly against the state of New York in the Court of Claims. They brought them to the prison officials. But as a result of that uprising, which 42 or 43 people were killed, there was an agreement that the inmates, now known as incarcerated persons, could bring a direct cause of action against the state of New York in the Court of Claims. So that quadrupled, if you will, the number of cases in our court. And then a couple of years later, Nelson Rockefeller was governor, and the Rockefeller drug laws were enacted May of 73. At that time, I think there were 18 judges on the Court of Claims hearing claims against the state. They recognized, the legislature did, and the governor's people, that we're going to need judges for all these cases that come in under the new Rockefeller drug law, all these felony cases. So they realized they could expand the Court of Claims, because that's provided in the Constitution, the number of judges on the court, the legislature can increase. They increased by, I think it was 32. So it went from 18 to 32, and ergo the 18, which were hearing cases against the state, they became paragraph A under the statute. And then paragraph B were the 32 or so Rockefeller drug law judges who were sitting in New York City in the 5 boroughs hearing heavy felony cases. And indeed, the court has expanded over time. We have other paragraphs up through E. And indeed, there's a total of 86 judges statewide. 27 of those judges are the paragraph A side of the court that hear claims against the state of New York. So again, moments in history, actions by certain governors have continued to expand our court by the number of judges. And of course, the jurisdiction of the court has expanded as well. It's a court of limited jurisdiction. We just hear cases against the state of New York on the paragraph A side. Those that are on the other paragraphs, they're immediately made acting justice of the Supreme Court, and they have either civil or criminal jurisdiction, depending on where the chief administrative judge assigns those judges. That basically is the history of the court, and some of our other panelists here will get into the specifics as to what is actually how the court moves forward. Huh?
Let me take a step back. So only 27 of 86 are hearing what are classic Court of Claims cases.
Yeah, that's right. Even the governor selects, nominates, and the Senate actually confirms. And the governor decides who's going to hear the claims against the state of New York and puts those folks on the paragraph A side, the original constitutional court.
Judge Rivera, let's fast forward to the back to the present. What type of cases do you hear and decide as a Court of Claims judge?
Well, the types of cases that I listen to are what they call civil cases. They're matters where claimants are seeking legal remedies in the form of damages against the state of New York. Our court doesn't award equity relief for those kinds of cases, specific performance, injunctions, or vacature. We don't deal in that area, and we also don't award relief for domestic relations or family law matters. There are no juries in the Court of Claims, which I often have to remind the trial attorneys that we're not in Supreme Court, and they don't have to engage in the theatrics. That's just me. They're just presented it before me. And judges decide these claims based on a review of the evidence, the testimony that's been provided, and the written decisions by the trial attorneys, the post-trial briefs. Our decisions are provided in written form, and like most trial courts, our decisions can be appealed to the appellate division. The rules of evidence in the Court of Claims are the same pretty much as they are in the Supreme Court. The burden of proof is the same, except for cases involving unjust conviction and confinement, which the burden of proof is a little higher there. It's by clear and convincing evidence. Those are the 8B claims. That's pretty much what I hear. Would you like me to talk about what kinds of cases within the civil context I deal with?
Yes.
I deal with cases involving civil lawsuits that are usually slip and falls, people who may injure themselves on state property. I also deal with if there's property damage. And sometimes, for example, I had a case where the New York State Department of Transportation entered into private property and allegedly removed trees that it didn't have authorization to do so. And so the person can bring a claim against the state for that matter. We also deal with breach of contract matters. For example, a private IT company has entered into a contract with a state governmental entity and alleges that the state's failures and deficiencies caused it to not be able to complete the contract or live up to the expectations of the contract. I also deal with preside over matters involving unjust convictions, like I mentioned earlier. And if there's any kind of claim for appropriation of private property, which is a damage caused by permanent or temporary appropriation of private land and improvement by the state of New York, I also handle those matters. We also Judge Sise mentioned that the Attica uprisings, since the Attica uprisings, we do deal with matters involving incarcerated individuals, which Judge Leahy-Scott will elaborate on further. I'll let her discuss that matter. But those are the types of claims that, as a paragraph A judge, that I typically preside over in court.
Now, there are also a fair number of personal injuries, aren't they? Slip and fall at the Empire State Plaza. A tree comes down on somebody on the Taconic Parkway. So someone has been injured to some extent. And so that sort of a case would also be in the court of claims, right?
Absolutely. Anything that, where the state is alleged to have been responsible for that. Because our jurisdiction is limited. We don't have jurisdiction over people. It's just individual jurisdiction over the state or its related entities, and we work for the state entities.
I understand. Judge Leahy-Scott, Judge Rivera mentioned unjust convictions and incarcerated individuals, which brings me to you, because I know a significant number of your cases are brought by individuals who are incarcerated at any of the many state prisons. What sort of claims do these people bring? What are the cases that come before you? What sort of things?
Sure. So paragraph A judges, which we all are, in addition to what Judge Rivera has just described on our individual assignment calendars, we also here on our docket has many cases from filed by incarcerated persons. And generally they fall into about 5 categories. One being a bailment claim, where an incarcerated person has had their property either lost or stolen or missing. They will sue the state of New York for in a bailment claim to recover the value of that property that has been lost or stolen. Another type of claim would be involving assaultive conduct, where one incarcerated person may assault another incarcerated person. And the question always is whether there was a duty for the Department of Corrections and Community Supervision to have known or have reasonably foreseen that that incident could have happened. We also deal with assaults where where correction officers may assault an incarcerated person. A third type of case involves medical malpractice or medical negligence. Incarcerated persons are under the care and responsibility of the state, and therefore they're entitled to health services and meaningful health services. It's unfortunate that we do see cases that involve medical malpractice or medical negligence. And a fourth type of case would be that which we've already spoke about, some personal injury and tort cases where an incarcerated person may slip and fall in a facility, may slip and fall while playing basketball because of some defect. Incarcerated persons are involved in work programs, and they may become injured while involved in work programs. For instance, if they're working in a kitchen and they are scalded by some steam, or if they're in a work construction shop and they're injured by some kind of machinery, those are examples of those personal injury tort type cases. And then lastly, there's a type of case called wrongful confinement, that if an incarcerated person is subjected to sanctions as a result of discipline, they could be placed in the special housing units, which is called the SHU, or they could be placed in keep lock, which is they're confined to their cell. And if there is some issue relative to the due process, the hearing to which they're entitled, it would be considered a wrongful confinement. And we as judges would hear those types of cases and make the determination and award a monetary amount of money for the amount of time in which they were wrongfully confined. So those are generally the 5 areas that we deal with on our dockets.
And just to make clear, what we're talking about here is monetary relief. If someone believes they've been wrongly convicted, you can't let them out of jail. You can't grant them a new trial. You can compensate them because their liberty was wrongfully taken from them for X number of years, and they suffered various financial and damages and whatever, correct? That's
correct. That's on the wrongful confinement in SHU or keep lock. As Judge Rivera had referred to on our IAS dockets, we have what's called the wrongful conviction cases, which are different. Those are folks who have been convicted of a crime, and later on they have been exonerated for some reason that's consistent with our statute. And those cases are presented to us as that they were wrongfully confined for numbers of years. and we award monetary damages for the length of time that they were wrongfully confined in our state prison system. So I just wanted to point out the distinction between the two types of cases.
Of course, John, the length of time, obviously, as you just mentioned, there's the liberty loss, there's the conscious pain and suffering, what they actually endured during a period of time, what they actually witnessed, et cetera. So that would be psychological damage, perhaps, and physical damage as well if they're injured while they're there and something happens.
I understand. Judge Sise, Judge Rivera mentioned I think maybe a couple of you mentioned that at the Court of Claims, you're never going to see a jury. And how does that change things? Judge Rivera mentioned that, sometimes he needs to remind lawyers that, hey, you're talking to me, you're not talking to anyone else. So how does that change the dynamics of what goes on in a Court of Claims trial?
John, this is going to sound terribly, terribly arrogant. Jurors can be led astray by very, very good attorneys who have tremendous powers of persuasion and maybe, dare I say, chicanery. So having been trained in the law as a law student and a young lawyer and a trial practitioner myself, and then having been on the bench for many, many years, you get to see these tricks. And when Judge Rivera said you have to remind them, this is not a jury. With the jury, sometimes the lawyer will beat that dead horse. I've often said, not a jury here. You may move on. My way of telling the attorneys, I get it. And when all the histrionics start, I can say, not a jury here. And then they understand. And many of the attorneys who bring claims in this court are Supreme Court practitioners, and they're not used to just trying the case before the judge who has to decide the case. So I kind of give them a heads up. So it's a little different in that regard. Not to say you don't want them to prepare and have the appropriate sized exhibit. It used to always drive me nuts when someone would bring in a 3x5 photograph. And I would say, hey, I know there's no jury here, but could you spend a few bucks and blow it up a little bit? So it's a little, larger to see, those types of things, and you usually do it with a little bit of a twinkle in your eye when you say that. But it is interesting how some attorneys don't quite understand that we are the finders of fact. So you can prepare in that fashion. And nowadays, with all the great technology, we do see a lot of electronic, images that come up and proposed experts' proposals of, accident reconstruction, et cetera. That's all very helpful to us as well as the finder of fact. Yeah.
Are there attorneys who kind of specialize in Court of Claims? I mean, I understand to one extent a trial is a trial. On the other hand, football and rugby are different games.
There are certain law firms, certainly with the incarcerated persons, we do see a number of firms that handle many of those cases. And I think maybe the incarcerated persons tell one another, so-and-so is my attorney, and then phone calls go to that firm, et cetera. So they got a little niche there. But it's hard. I mean, I wouldn't say someone certainly doesn't just, all we're going to do is Court of Claims cases in our firm, but there are some firms that have more than others, and they become familiar with the procedure in our court. When years and years ago, I did a Demystifying the Court of Claims. 20 years ago. And it was Demystifying the Court of Claims, and there was a subtitle, Don't Refer That Case. And I would stress to the lawyers as we appear in front of different bars to give this CLE, look, just read the statute, read the Court of Claims statute. There are differences, but it's not, black magic. You just got to read it so you can prepare to present, first know it so you can do the proper pleadings and so forth, because we do have strict pleadings in this court. And it goes back to the whole waiver of immunity. If you're going to play in our game, you got to play in our rules. Because remember, the state of New York is self-insured. It's the public, if you will, the coffers. So yes, we're going to waive immunity, but you got to do A, B, C, D. And if you don't, some of the things, if you don't do, you're out of court. There's nothing we can do about it. You're out of court. So
I also think from my perspective, John, that I'm an Albany resident judge. I think the same attorneys and firms that have tort and civil cases, personal injury cases in Supreme Court are the same types of attorneys and law firms that we see in the Court of Claims. And to Judge Sise's point, so long as they're versed in the Court of Claims Act, it's fine. The transition is fine.
Yeah, and I'm down in New York City, John, so there's a bigger pond, if you will. So I see a lot more firms down there than in a smaller community. That's why I really don't know that there's any. I couldn't tell you right now what firm would you say has been in front of you, more times than the others. I really can't say because there's so many different firms down there that handle, litigation, right. Civil litigation, this nature, torts, and so forth. contracts.
I
and so
do.
forth.
Here in Syracuse, I see many of the same lawyers who have developed a certain expertise in the Court of Claims. We're a smaller community, and people do tend to gravitate towards the things that they do best. And there are 2 or 3 firms here who attorneys from those firms that I see quite regularly in the Court of Claims, at least in my court.
There's 8 districts across the state of New York in the Court of Claims. From west going east, Buffalo, Rochester, Syracuse, Utica, down to Binghamton, Albany, New York City, White Plains, New York City, and New York City. The New York district is New York City and Long Island. We're really the last circuit riding court. When you come to the New York State Court of Claims, you're going to sit where there's a need. So all of us have had occasion to be assigned to a different district. When I first got in my first 2 years, I was in Long Island, yet my home was up here in the Capital District. We're expected to travel. And indeed, under the Rockefeller drug laws, many of the judges from around the state were sent down to New York City. And to this day, some upstaters might get assigned to a paragraph B court, acting JSC, and they're expected to be there during the week and work.
So it's not like there's a Court of Claims in every courthouse or every county.
Correct.
Judge Rivera, if an attorney is about to argue a case before you in the Court of Claims who's never been there before, what is your advice to that attorney? Be sure to do this. Do not do that. What would you recommend?
Well, I normally have a script that I go through, and just letting people know that what the Court of Claims is, and if you haven't been to our court, this is how we handle things. And when you ask for exhibits, be sure to let the court monitor know. They'll place them here or there. And some of the attorneys who've never been in the court will ask that question. What's the Court of Claims like? I usually refer them to the website to familiarize themselves with the Court of Claims Act. And I tell them, look, lays out the procedure and the process here. And these are some of the things that we follow, the rules that we follow. And if, it's pretty much the same as what you would expect to adhere to in Supreme Court. We do have certain nuances that are a little different in the court, but it's not unlike most civil courts that you've been in. And in some respects, we're a little more civil when it comes to how we behave in court. I mean, surprisingly civil, how well the attorneys act in court.
Why do you say that?
It's just a different vibe. I've heard court officers who've even made that statement that, Judge Rivera, I got to tell you, your court is so professional, the way that the things are handled here. The lawyers aren't screaming at each other. We lay it out. I lay it out early, these, as Judge Sise pointed out earlier, I make it a point to remind him that this is a bench trial format. There are no juries here. You're speaking to me. Present your evidence. Be respectful. If you need a break, let me know. I go through a whole outline of things that regarding behavior and conduct and the decorum that I expect the attorneys to demonstrate in court. And that usually sets the tone. And I require them to stand, when they're asking questions, because I remind them that these microphones, they don't amplify your voice. They're only for recording purposes. I need to hear you. Your opposing counsel needs to hear you, and the monitor needs to hear you. So there's just this specific conduct that I'm requiring of them up front. And it usually tends to work. There's no discord. It's one of the most civil environments I've ever been in.
Judge Rivera just mentioned about the recording process. We don't have stenographers like you see in the other courts. It's recorded into the computer hard drive. When I first got here, it was actually tape recordings, but it now goes right into the computer. So we have to remind attorneys, unless I say off record, whatever you say, even sotto voce at your table, I hear. And sometimes there's pretty funny comments, especially when they're commenting on the judge. It's pretty funny,
And then in the days now of virtual trials that we've had pre-COVID, but we are all engaged in, we also have to remind the counsel to turn their microphones off on their virtual teams, because unfortunately they have said a few things that they wouldn't not want the opposing party to hear, less the judge. So, but if I could just briefly just dovetailing off of what Judge Rivera had said, one of the things that we have done in the Court of Claims is we've developed a PowerPoint presentation called Demystifying the New York State Court of Claims, which the three of us, Judge Sise, Rivera, and myself, as well as many of my Paragraph A judicial colleagues, have been presenting to bar associations and attorneys around the state, which provides them with the historic background of the Court of Claims. It also provides them how we practice here in the Court of Claims. We provide them with basically the answers to the tests that they may be asking, which is the most important thing you need to know about the Court of Claims is the Court of Claims Act. You have to know that backwards and forwards because, as Judge Sise spoke to earlier, the sovereign immunity issue, there are specific ways in which you must bring a claim in the Court of Claims, the timeliness around it, what should be included in the claim, and those matters could potentially be jurisdictional defects. So we have been making these presentations now for in excess of a year, educating attorneys on Court of Claims and the Court of Claims practice. First, because we'd like to have these attorneys know about us. And secondly, it's because of our Equal Justice in the Courts initiative that we have here in the Court of Claims that I could speak to if you want me to speak to now.
Absolutely, please do.
Okay, so we have a very robust Equal Justice in the Courts committee here in the Court of Claims. And one of the, and you've heard the type of work that all of the Paragraph A judges participate in. And many of the judges, as part of our Equal Justice Initiative, identified first with specificity incarcerated persons who may not be able in the best manner present and prosecute their claim. And it was because they were unfamiliar with either the Court of Claims Act or the Court of Claims process. And then as we spoke collectively with all the judges in Paragraph A, it was decided that perhaps we as a court should start establishing an attorney referral program to have attorneys first, again, learn about the Court of Claims, and secondly, to first volunteer to represent incarcerated persons. We've expanded that not to include just incarcerated persons, but it should be really anybody pro se in the Court of Claims who is in need of attorney for assistance. So we've been working on this initiative for quite some time now, and it's really been a two-pronged approach, which is first to initiate and establish a pilot program, which we are finalizing now with our partners being, stakeholders being, and we appreciate very much, the Attorney General's office, because the Attorney General represents the state and defends the state on all claims. And then secondly, we're going to start our pilot program involving several correctional facilities and incarcerated persons within those correctional facilities. And so one of our partners and stakeholders is the Department of Corrections and Community Supervision. And both agencies have signed on and are also very excited about this initiative in the Court of Claims, because the best cases are obviously those in which the clients are represented and represented well. So the first prong is to have those stakeholders involved so we can start a program. It will be a pilot program again for several facilities in the state of New York, and have attorneys agree to participate in this program and represent the claimants, incarcerated persons. And then the second prong, which I previously spoke about, is to educate attorneys as to Court of Claims, the Court of Claims practice, and to really be soliciting attorneys to join this program. And we are very fortunate that one of our retired judges, just retired last summer, Judge Deb Martin, has agreed to stay on in a volunteer capacity at this juncture to assist us with this program. And she's really the director helping us put this program together. So any of your listeners who are interested in joining the attorney referral service program that we're starting and representing claimants in the Court of Claims, they could reach out to Judge Martin, and her email address is damartin, DAMARTIN @newyorkcourts.gov. And if they would just contact her, and we can put the attorney on a roster that we're developing to represent, at least at this point, the pilot program involving incarcerated persons.
Judge Leahy-Scott spoke about the Equal Justice Initiative. Why is that important to you as the acting presiding judge?
Attica uprising gave the incarcerated persons access to the court. And the equal justice in the court, which we're putting forth now and looking to get attorneys who are able to represent, willing and able to represent the incarcerated persons, that is the equal justice. Because as I likened it, it'd be like me walking into the ring with Tyson Fury, right? WBC heavyweight boxer. But I walk into the ring, and not only am I in the ring with a professional boxer, but my arms are tied behind my back. So the incarcerated persons all these years have been prosecuting their own cases against trained lawyers on the defense side, the Attorney General's office. And one of the things that I always try to do, and I try to impart to all the judges who come to our court, give the litigants an even playing field. And it has never been an even playing field having an uneducated, certainly not a legally educated person bring their own claim or represent themselves against an attorney, trained lawyer, trial or experienced trial lawyer. So by creating this panel of volunteer lawyers, it's going to give representation. Now, John and Jane Q. public may think, their first thought may think, why should we? They're in prison, for gosh sakes, for doing something nasty, something terrible. Well, the answer is these folks who are convicted, they got to do their time. The whole idea is rehabilitation because they will rejoin our community. So sure, take away their time, their liberty, if you will, that's the punishment. But if they're injured as a result of negligence by the proprietor, state of New York, who's taking care of them, give them an avenue, which they have and had since Attica, but give them representation so they have a fair chance of representing themselves and perhaps if they're lucky enough and they have the evidence, win it and get compensation for the injury they sustained as a result of the negligence of the proprietor, state of New York. So honestly, if John and Jane Q citizens should recognize and you want them, you know they're returning to society, and the vast majority are there for a lot of economic crimes, a lot of drugs and so forth. Certainly there are those in prison who have committed violent crimes, but some of them are just passion, some of them are because they were intoxicated when they did it, et cetera. They're going to get back into society. They do their time. So treat them like fellow human beings while they're in. We know that. All the studies have indicated that. Treat them like real people. And again, they're incarcerated persons, no longer inmates, right? So I'm very excited about the program. I do hope some of the attorneys that are listening, some of the firms that have young lawyers who aren't getting into court all that quickly, can reach out to Deb Martin, get on the list. We'll get you some cases.
There seems to be a dual benefit in that. I mean, one, the obvious benefit to the individual who may not be equipped to represent themselves, but also a benefit in the development of the law. You occasionally develop with novel issues that probably ought to be fully developed because they're going to be appealed and they may decide what the law is. And it would seem that it will be advantageous to have someone trained in the law, someone who can point out those issues, someone who can develop them. So if an appellate court reviews it, you get a full review of whatever the novel issue happens to be. Is that right?
Absolutely. And then finally, these cases that are brought alleging negligence, like any other case, when you see these cases brought against the toy manufacturer and a lawsuit's brought, guess what? They change how they make the toy. So if there's injuries occurring as a result of the negligence of the state of New York and how they run their prisons, well, and there's a couple of these cases that go on and there's win, et cetera, it gets back to them. And then they got to correct the problem so others don't get injured, right? When you get injured, there's more cost for the taxpayers when you're taking care of these people. Attorneys listening should understand, we're not just soliciting volunteer, do pro bono. You'll have an opportunity to handle cases where indeed you'll be able to collect the 1/3 contingent fee or a little different with the medical.
Right. And on the several cases that I've previously described, there are some types of cases, for instance, the bailment cases, they don't involve large amounts of money. And we would anticipate that we would have a pro bono panel to represent incarcerated individuals relative to those claims. However, as Judge Sise said, medical malpractice, medical negligence, your slip and falls, your torts, and your assault of conduct are it could potentially have verdicts in it that involve large amounts of money. So we would anticipate having the attorney referral service and saying to the attorneys, you're entitled to a contingent fee. That's between you and the client. We are just the service, a court-based service, to put the client and the attorneys together.
That's fascinating. Well, thank you. So that tells us how we get certain people come to the Court of Claims. Now, I'd like to know how you came to the Court of Claims. We only touched on how somebody becomes a Court of Claims judge, and I'm hoping that we can amplify that each with your own individual story. So, Judge Sise, why don't you start off with that?
Sure. Just backing up a little bit, I'm not sure we covered it, but it is a gubernatorial nomination, and it's on the advice and consent of the Senate. So it's a Senate confirmation process, and it's a 9-year term. Supreme Court's 14, county surrogate family 10. Not sure where the 9 years came in, but it's been around on the books for some time. 9-year term, and it's a static end date. So, for instance, I came in, I took Jim King. Judge Jim King retired at 70, mandatory retirement 70. He only had 4 years left of his 9-year term. When I was indeed nominated and confirmed in 2000, I took the balance of his term. So I've been up a couple times since and gotten full terms, and now I'm actually in a holdover status, waiting to be reappointed. So how did I become involved? Well, John, you know that I'm from a family of judges. I grew up with a judge. My dad was a judge for 30 years. My brother Joe became a judge before I did. And four or five of us, whatever, of the 9 sons are lawyers. So we've been in the law forever and a day. It was part of, who the Sises were. And I did get involved in politics. Didn't intend to, but I kind of backed into it for, different reasons. And I got very much involved in it and ended up becoming a town chairman, then a county chairman and so forth. So I actually got to know, some of the players on the state level. And I realized that there was a court of claims, and I realized it was gubernatorial appointment. And as my brother Joe said to me, these icebergs only opened and then they closed for a long time. If you have an opportunity to, seek an appointment, nomination, and confirmation to this court of claims, I'd go for it. I said, okay, give it a shot. I gave it a shot all those years ago. And that's how I did it. I mean, I went through, if you will, the political way, but I will say I am pleased that I had many years as a trial lawyer, initially as a Bronx assistant district attorney for a number of years, and in a private practice in Manhattan before I came back home to Montgomery County, Sise and Sise, the family business, and forever and a day, 11 years, I think, with my brother Tommy and my dad retired, joined us. I did all the litigation. I was in court all the time. So I do feel good about the fact that, yes, it was a political appointment, no question about that, but I brought to the table a lot of years, 18 years of practice before the courts. So that's how I got here.
Mine's a little different because I've spent the bulk of my career in public sector. I've been a local and a state prosecutor. I was also a defense counsel. My last employment before becoming a judge, I was the Inspector General of the state of New York. And in that capacity, I had many investigations which were reported in the press and otherwise. But the last most notable investigation was involving the 2 incarcerated individuals who escaped from Dannemora. And I wrote a report and then Stiller decided to do a movie on it in which Bonnie Hunt played me. And as a result, I do believe as a result of the various investigations I was involved in as Inspector General, and particularly that last one, the then governor at the time had nominated me to the Court of Claims position, which quite frankly was very much a surprise because I had intended to continue as the Inspector General for a 3rd term. And when I was approached to and was nominated, I was extremely, privileged and honored, and it's a humbling experience. I went before the Senate Judiciary Committee in the Senate, and I was confirmed. And so now I've been a judge for almost 5 years, but that really was my path to how I became a judge.
Judge Rivera, what's your story?
Oh gosh, nothing as colorful as Judge Sise or Judge Leahy-Scott. I mean, I practiced law for 27 years before I applied for appointment to the Court of Claims. Before that, I was a professional boxer. It's an amateur champion for a while, amateur boxing champion, and the law was something that I'd always wanted to pursue from a young age. And practicing law, I grew into a desire to want to become a judge someday. And it's just, I went through the process, the application process, was fortunate enough to have been nominated and confirmed by the Senate. I've been on the bench for 2 years. It was a remarkable experience going through the whole process, very emotional, culmination of a lifelong dream, just overcome with emotion of having gone through that process and been nominated and confirmed by the Senate. So that's my story.
So let's say someone, a young attorney, hears this podcast and thinks, gee, I'd like to be a Court of Claims judge someday. How do they do it?
First, you got to be a member of the bar for 10 years before you're eligible. If you've been a member of the bar for 10 years, you can apply. You should go to the governor's website, go to the New York State Governor's Judicial Screening Committee, and you'll see the composition of that committee. And then there's an attachment You can get right to the application form, like a 47, 48-page application form that you have to fill out. Takes some time. It does take some time. You fill it out and you submit it to the governor. Governor looks at it through the counsel's office. They set up a screening, if you will, interview before the Judicial Screening Committee. You then appear before that Judicial Screening Committee. You're either found highly qualified or not qualified. If you're found highly qualified, you're passed on to the governor. The governor decides whether she wants to nominate you to the Court of Claims. That's what you do from your end. And, obviously, since it is a nomination by the governor, and it is a trial court position, that first 10 years of your practice, try to get to court as often as you can, become known as a trial practitioner, because that's awful nice when you come to the Court of Claims. If you can have that, it's not absolutely necessary, but it's great to have that trial experience. I can tell you, as the acting PJ of the Court of Claims, I like it best when I see somebody who's got some trial experience, has been in the courtroom, makes it easier, if you will. And then, of course, you can get involved in politics as well. Join a local political party and volunteer your time. Let the political folks know who you are. Because at some point, you may be asking a person, could you write a letter for me? Could you contact the senator? Could you contact governor's office and let them know I got my application in? Right? Again, it's going to come up to the governor and the Senate as to whether or not you'll be selected and confirmed. That's really how you get it.
And dovetailing on that, what Judge Sise said, a young attorney out there, it's important for that person to make sure that they guard their reputation in the community. Because a lot of the people that you're going to be asking to give referrals on your character and fitness for judicial office are going to be folks that you run into in the courtroom and on the streets and so forth. So I tell a lot of young attorneys when they ask me, Judge, what should I do? I say, guard your reputation as if it were gold. Pretend that every encounter that you have, whether it be in court or whether it be in an office with your adversary, you're interviewing. Pretend that you're on an interview because you are being interviewed. People remember the kind of person that you are. And that comes back. I remember through this process, the application process with the screening committee, the person who was reviewing my background and qualifications, they had contacted everybody on the list, everyone on the list, in addition to other people that they had asked people on the list to refer them to. Guard your reputation. Don't be a difficult person to deal with.
Yeah, and keep in mind that you are seeking a judicial nomination. So it is about civility. It's about respect to everyone. And the fact that you are going to be judging. So to Judge Rivera's point, every person you meet, you must be civil, you must be respectful, because that's what is going to be expected of you when you become a judge.
So my journalistic roots bring me back to a follow-up question, which I can't help but asking. So what are the similarities and differences between being a Court of Claims judge and a boxer, Judge Rivera?
Well, it doesn't hurt as much. That's for sure.
I'm glad to hear that.
Yeah.
Judges, thank you so much for your time and your service.